start. The trial court also held that the onus to prove that the agreement to sell in question was not intended to be an agreement for transfer of the property, rather it was intended to be executed as a security for repayment of loan amount taken by him was upon the defendant stop. However, he was failed to prove his plea regarding the agreement being a document of security for repayment of loan stop. The only witness examined by him, DW2, has admitted in cross-examination that he was not even present at the time of the execution of the agreement in question stop. Hence, the trial court held that the agreement to sell stands proved as per the requirement of law stop. The defendant has not been able to extract anything from any of the witnesses of plaintiff to show that the agreement was intended to be a security document for repayment of the loan stop. While dismissing the appeal filed by the defendant, the lower appellate court also upheld the finding recorded by the trial court that by examining the attesting witnesses, the plaintiff has proved the agreement to sell in question stop. The lower appellate court also recorded a finding that the defendant has failed to prove his plea regarding the agreement in question being a security document for repayment of the loan which the defendant claims to have taken at the interest rate of 2% per month stop. After hearing the counsel for the parties and perusing the record with the able assistance of the counsel for the parties, this court is of the considered opinion that the argument raised by the defendant appellant do not deserve acceptance stop. The agreement in question has been duly proved by the plaintiff by examining the attesting witnesses as well as the scribes stop. The plaintiff could have done only this much to prove his claim before the court to show that it was an agreement intended to be as it has been recorded stop. This onus he has fully discharged stop. Even the counsel for the appellant defendant could not dispute this fact that he has been able to prove the agreement by examining the attesting witness stop to prove the plea that the agreement was meant to be a document of security of loan which he had taken at the rate of 2% per month. The defendant has not led any evidence stop. He has not disclosed even the purpose for which he required this loan stop. On the contrary, he has admitted that the amount of rupees 10 lakhs taken by him from the plaintiff was lying in the saving bank account of the defendant stop. He has also not led any evidence to prove that he ever paid the monthly interest to the plaintiff at the rate of 2% as claimed by him stop. So the defendant has miserably failed to prove his plea that the agreement in question was only a security document for repayment of loan available by him stop.